morning, WTOB listeners. I'm Dylan Greenwood here with Harold Eustache on For the Record with Greenwood Law. Thank you for joining us here this morning. We also like to give a special thanks to the people here at WTOB who help make our show possible. They do an excellent job with us, so thank you for that. What we're going to talk about today, here on Greenwood Law, we're all about your rights, protecting your rights, informing you of your rights. Well, one of the things that we've never quite touched on in depth that I think sometimes you just sort of take for granted as a defense attorney are the defenses.
All right.
It's just something that we think of, we know of, we carry them with us in the back of our mind each and every time that we step into a courtroom or talk to someone on the phone or in person. And so today we're just going to kind of go down some of those and talk about what they are, how they work in a court of law, which can be quite different than how you might see it pan out on like Law and Order, for instance. So, I think what we're going to do is kick off, Harold, with some of these bars to being able to be prosecuted even in the first place. And I think the first one is double jeopardy, which there's a really famous movie about, and there's a lot of people.
People think they know what double jeopardy is.
Bring it up a lot. But you think you know, but you have no idea.
Right. And so double jeopardy comes from the Fifth Amendment in our Constitution that essentially says that a person cannot be tried twice for the same offense, essentially, for the same criminal conduct. And how that actually plays out is pretty complicated as to how that plays out, not the most intuitive thing, and part of that is because there's just a lot to it. So there can be a lot with, does that play out on the state and federal level, or when does jeopardy attach in a case, so that double jeopardy is a thing. So there's sometimes that we go into cases and proceed down a course in a case, and something happens, and we have to come back to that case, or it needs to be retried later, or when does jeopardy attach. And so all those things are important to look at and to see if a person, if that bars a person from being prosecuted. Did you want to get into the specifics on them?
Yeah, and I mean, double jeopardy attaches what we call arraignment. There are actually times in which the state of North Carolina can take a dismissal on a case, or maybe they say that they're unable to prosecute a case, but if witnesses show back up again, if new evidence comes to light, there's a chance that they could bring those charges back up because double jeopardy hasn't attached. Basically, arraignment is that formal time that you go and you say guilty or not guilty. And that's just the easiest way to think of it. And so once that happens, that's when jeopardy all of a sudden attaches. So I think that's an excellent overview that you gave. One of the other big bars is something called ex post facto. And this has nothing to do with the post office doing anything. It's a constitutional right that you have that's given you by the United States Constitution, and it's also recognized by the North Carolina Constitution, because there's a lot that North Carolina did to kind of mirror the United States Constitution. But basically it says that if you do some act, let's say that picking up a red Solo cup on today's date is a perfectly legal act, and then the next week all of a sudden the legislature passes a law that says it's illegal to pick up red Solo cups, and this law goes into effect the following week, so 2 weeks later from the original act that you picked up a red Solo cup, the state cannot come back and charge you for the law that they're saying that you would have potentially violated, because you did it before the law was ever enacted.
Sure.
You weren't on notice that could have been a violation of the law. Now, that being said, we get calls all the time where people say, well, I didn't know what the law was. I didn't know that was a violation of the law. Ignorance of the law is not a defense. That is never going to be a defense. In fact, that's just a terrible argument all the way around. because you should know. You should know what you can and cannot do per the laws of the state of North Carolina, the place where you live, laws of the United States where you live. But this is a time where you were not on notice because it wasn't even a law on the books. And so that makes it a bar to prosecution.
And the founders, not to get too much in depth, but the founders had a real issue with this for other reasons. They didn't want anybody to go back and charge them with certain things. So they were very, very uncomfortable with being charged ex post facto. And it plays out a lot for us in sentencing, actually, because not just for a new crime that the state can't charge you with, but also if they change sentencing. So, for example, if picking up that red cup was illegal, but it was only an infraction and you could only get a fine. Or then next week it is you can get 60 days in jail. Well, they can't come back and punish you for that 60 days in jail. You have to be on notice about the punishment too. So that plays out to us sometimes when we have people that have pretty old charges. They do have to be sentenced by at the time that they were charged. Another one is lack of jurisdiction. This is one that we deal with a lot. In every case that the state prosecutes, they have to prove jurisdiction. So it is something that every prosecutor knows, every defense attorney knows, that it's one of the standard questions. Where did this happen? Did it happen in Forsyth County, North Carolina, and sometimes they'll name a street or an area known in Forsyth County. And that's generally enough to show the jurisdiction. But this can be an issue. I had a case recently where it was communicating threats. And sometimes, if that threat happened over the phone from one county to another, this happened where the argument was in Davidson County and we're in Forsyth County prosecuting the case, but they were driving together to a place in Forsyth County. So the issue was, well, where did the threat actually happen? So that can definitely be an issue in some of the trials we have.
Yeah, and it's an issue too, not just for the charging document, and we've had a prior episode on, all the different types of charging documents, but it's also something that has to be proved at each and every trial. Mm-hmm. And that's kind of one of those things that you're always listening for, of whether or not the prosecutor has proven through some sort of testimony or exhibit or whatever else that whatever was alleged to have taken place took place in this county where the person is being tried, or else they have not established at the hearing, at the trial, that jurisdiction was proper for whatever was going on. Another one that I've actually argued recently, you've argued jurisdiction recently, I've argued recently, was statute of limitations. And it came up for me in a very weird case for failing to appear for prosecution on a DWI, which mm-hmm. is a law in our state that if you fail to appear for 2 years following your failure to appear for a DWI, then that is a separate crime on top of the DWI itself.
Right.
And so it brings up this weird statute of limitations issue. And what statute of limitations is basically saying that you should not be on perpetual notice or worry about some sort of litigation coming against you for whatever you've done, whatever act you've committed. Now, that being said, there's a big caveat to that. And the big caveat to that are felonies. Some of our listeners out there might be going, well, what about these cold case murders that you hear about? Or what about DNA evidence that gets used to prove a felony many, many, many years later? Well, again, that's where felonies are the exception, where the statute of limitations is forever or until that person dies, basically, the person who would have been prosecuted. For misdemeanors, it's 2 years. So from the date of offense, the state of North Carolina has 2 years to bring charges against you. Now, there are some weird little quirks and ways in which that gets told and which that gets calculated, but generally speaking, 2 years, statute of limitations, they have to bring the charges. The other one that happens actually more that we see in the federal system than in the state system is immunity. Mm-hmm. And so there are times, and And if you watch enough Law and Order or any kind of FBI show or anything, they're handing out immunity left and right because they want to get the big fish. And if they catch someone smaller down the line, you give them immunity for whatever they do from that point forward, and they'll help prosecute. That's how law enforcement officers are able to use like confidential informants, do controlled buys of drugs, that sort of thing. Because that person is working for the government. They've been given immunity for the types of stuff that they're doing, and they're not going to be prosecuted for what they're doing to help the government. And that kind of immunity can be far-reaching and can be quite broad. There are usually caveats carved out for that type of immunity for violent crimes or for stuff that is not necessarily authorized by the government or condoned by the government in furtherance of an investigation. There's usually these caveats that are carved out.
One we have here in North Carolina that's a specific type of immunity, it's a statutory immunity, is when and it was put in place to kind of guard against some of the stuff going on with the opioid epidemic we have. When someone overdoses, let's say two people are together, one person overdoses, and they call the authorities in order to save that person's life. If the authorities see, that the person who called is in possession of a narcotic, be it some sort of opiate or some other narcotic, they can't be charged. They're immune from being charged with the possession of that when they're calling to save someone else. So I've actually had to use that multiple times. I've seen it used here in Forsyth County multiple times. It's kind of up to the defense attorneys to know that because it's not, the most known thing, but it is an immunity defense that we have here.
That's true, and there's also one kind of that same vein, for lack of a better way to put it, for needle deposits.
Right.
It's right. Kind of in the same sphere, and I've had to use that too, where you're able to show somebody's got a card where they're going to deposit these needles for safe drop off, and they're not supposed to be charged with certain things, but those are very specific, carved out forms of immunity for very narrowly tailored types of acts that people do.
Right.
So those are all the bars. Those are ways that you should not be prosecuted. So those are bars. Then you have defenses. Defenses are usually saying either that you weren't there, that's an alibi, or that whatever you did was justified in some way. That you're saying, yeah, the act occurred, and I realize that the act occurred, but I was justified due to some sort of issue that was going on.
Right.
So those are obviously different. So just real quick to talk about alibi, that's a common one that gets thrown around. And, it's actually one of the first things I always ask about. When somebody tells me that they're charged with a crime, I go, well, where were you? Where were you at the time? And, every now and then somebody's like, well, I was clear across town, and they're saying that this happened, 2 counties over, and, stuff like that. And I go, well, okay. And then you start thinking of all the ways that you can prove that. And, you're looking for different pieces of information, people that can identify this person, all sorts of things to try to prove an alibi. And that's something that can say, listen, I have no knowledge that this could have even have happened because I was clear across town. And we've actually used that in a case where the state recognized the issue from the very beginning. We were able to show via certain GPS data that our client was almost an hour away from when the crime occurred, and we had a exact time of when the crime occurred. Like, everybody knew the time, and we were able to show that, hey, this was an alibi for all of this. But that was a pretty unique circumstance.
Yeah. Going back to what you hit on earlier, dealing with a lot of these defenses, you're admitting that this stuff happened, but you have some reason. One of the most common ones we see all the time is self-defense. And we've talked about self-defense.
That was our first show.
On the show, our first show. It's nostalgic for us. We've talked about self-defense many times, and without getting too much into depth on it, it is an affirmative defense. It is one of these defenses that, of course, you're saying the act happened, but I had reason to defend myself against somebody for various reasons. So it can be in defense of yourself, in defense of others or property as well, and that can be a defense to a crime. The classic one is just an assault. Mm-hmm. You were assaulted, but you had reason to assault someone. Another one that is important for us, and I think is in the courts a lot, and the courts deal with is necessity mm-hmm. and duress. And they seem like they are pretty close, but there's a little difference between the two of them. But just to think about necessity, specifically the crime that we see him a lot in is DWIs, and this defense brought up. And so when you bring up the necessity defense, it's that, yes, the person was driving, yes, they were in a public vehicular area, all that sort of stuff, and yes, they were impaired, but it was necessary for them to drive. A classic example would be a person's at a bar and they were going to call an Uber. Their car, they did drive there soberly, but they were going to call an Uber. Somebody comes in with a machine gun and threatens everyone. The person gets out of there really fast and drives away, and just right as they're driving away, they get pulled over. Well, was it necessary for them to drive? Did they have to? Another example of necessity can be domestic violence in the home. Mm-hmm. They're getting assaulted in their home and they have to drive away. Either way, that can be a defense to DWI or other types of crimes.
Right. Yeah. And necessity, a lot of times necessity and duress are kind of intermingled. It's mm-hmm. easy to. It's really, really easy to. The way I think about the difference between the two of them is that necessity, there's usually some like outside force that is causing you to have to do something. So I think there's this classic example in case law in North Carolina where a guy it was like in the middle of an awful storm. He had a boat and saw another boat capsize, and he took his boat and moored it at a private dock. So he technically trespassed by mooring it at a private dock where he wasn't supposed to be, but he did so for the purposes of saving the people and getting out of the storm and getting everybody to safety. And at that point, you're going, well, yeah, you committed trespassing, but at the same time, you saved 5 people's lives by doing it. That's totally just, that was necessary for you to do that because we value human life more than we value the fact that you tied up a boat to a pole that you shouldn't have randomly. Big deal. I would argue, or I think in my experience, necessity is rarely litigated in a courtroom.
Rarely. I agree.
Because I think a lot of times it is something that is able to be presented to the state of North Carolina before you ever go to trial. Mm-hmm. And it's one of those judgment calls that I think most people get. I mean, just like my example of like somebody saving someone's life. One time I had a case where, somebody had to make quite a drastic maneuver on the highway, but they did so because they knew that someone else, passenger in their car, was having an emergency situation. So they needed to make that unsafe lane change, to get across, to get the person to help. And while they did get pulled over, that was something that we were able to explain and say, this wasn't the normal course of events. They needed to get off. They needed to do that. And duress is kind of similar to that because in duress, the classic example there is holding a gun to someone's head.
Right. There's an element of fear in duress that where necessity you might not have that sort of, that element of someone, a third party holding a gun to your head. You could, but duress is, before the show, I was talking about a case that in my first year of law school, I worked for a judge and we had a trial, and the case was about a 17-year-old kid, former gang member trying to get out of the gang. The gang said, okay, in order for you to get out of the gang, you have to commit this burglary and if you don't, we'll threaten to either kill you or your family. And they essentially held a gun to him while he's committing this burglary. So the trial, it wasn't in question whether or not he was there or whether or not he sort of committed this burglary, but whether or not he was under duress. There was he was with another co-defendant, whether or not he was under duress, and that would be the type of defense against committing that type of crime.
Good morning, WTOB listeners. Thanks for joining us here. And if you're just joining us here on WTOB, on For the Record with Greenwood Law, Harold Eustache and I are talking about different bars and defenses to criminal prosecutions in the state of North Carolina. And these are all the ways in which that if you're accused of something, basically you could potentially get out of it. And we've touched on all the different ways in which the state of North Carolina should not be able to prosecute you. And we've now delved into some of the defenses that justify actions that you may have taken. So you may have committed the crime, but you were justified in doing so. And so another one of those is the insanity defense. And this is a common one that gets pled, especially in our most serious of crimes that happen in the state of North Carolina, where basically you're saying that at the time the crime was committed, that you and what was going on in your head, you were under such mental defect that you didn't have the ability to come up with the reasoning to figure out that whatever you're doing was right or wrong. That's kind of the way to think about it.
It is. Right.
That basically your mental capacity at that time was deficient. It triggers so many things that happen when this defense is pled.
It does, and it's important to note that it's not enough to just say I was angry or I was kind of out of my mind for that second. I mean, you really have to show that there was a disease of the mind.
And it's also not enough to say that I deal with depression or
Sure.
I deal with anxiety or bipolar disorder. You've got to be able to show a connection.
And that it's substantial enough, that's truly substantial enough to show that you couldn't differentiate between right and wrong, and you can prove that. This is, when you assert a defense like this, the courts have said the presumption is sanity, that a person is sane that is walking into a courtroom. And so the defendant needs to prove that they are insane and has to really show that to the finder of fact, be it a jury or who else. And if they are able to show that, the state doesn't have to show evidence to the contrary that the person is saying. That it's really up to the defendant to prove that. Mm-hmm. And it is not the easiest thing to prove. I know it gets thrown around a lot. It gets thrown around on TV a lot. Mm-hmm. It's one of those defenses that I think everybody kind of knows, but it is certainly not used as commonly as people would think. And even if you are granted, insanity, it doesn't mean that you're going to be exonerated totally. It doesn't mean
not at all. I have seen people that I'll never forget this. A person who smiled at the pictures of what he did to an 18-month-old. And it was picked up on in court by the judge. It was one of the most disturbing things I think I've ever seen. And there was not an insanity defense there. He was pleading guilty. And they had him assessed and done all the stuff, but there was no insanity defense. And someone doing that certainly makes you wonder about mm-hmm. what's going on in that person's head for sure.
And a lot of times, even if you are given that insanity, the court finds the finder of fact finds that you are insane criminally, you would still be subject to be committed mm-hmm. To a civil commitment and have a proceeding to be sent away and put in a state facility that says you're insane. So it's not like you're going to be walking free and just going to Chick-fil-A after that.
Right.
Yeah, it's a tough one.
Some of the other ones, obviously that's one of the kind of main ones in that kind of justification arena, but some of the other ones are that you were unconscious or that there was some automatism. So basically it's called basically the sleepwalking defense.
Right.
You didn't know what was going on. It's the reason why, like, if you're sleeping in the same bed as somebody and you're dreaming and you accidentally punch them in the face, you're not going to be found guilty of domestic battery or something. It's you'd had no control over your body at that moment in time. You were dreaming and you flailed out, and so you would have an automatism defense, or that you were unconscious in some way. Now, there is a form of unconsciousness with intoxication that brings up a whole slew of issues, and there's a difference between voluntary and involuntary intoxication.
We might have to touch on that.
That might have to be its own show, because there's a huge difference between your culpability for you choosing to take a substance versus you not choosing to take a substance.
Right.
And that can make a huge difference in your case. And then one of the other things kind of in line with the insanity defense is diminished capacity.
Yeah.
And that's something where, if you, do deal with diminished mental capacity, it can be a very significant mitigating defense. And that is something I've actually used that in a case or two that I've had where we had a lot of medical records, and it usually something like that has to be established well before the act occurred. But I think eventually everybody was able to see that there was a mental capacity issue there.
I want to thank you all for joining us on For the Record with Greenwood Law this week. We talked about bars and defenses. Again, we want to make sure that our viewers and everybody out there knows their rights and asserts them. Please join us next week as we will discuss another important topic. We've got plenty of important topics coming up shortly, so we hope that you guys enjoy it and join us soon. But before we go, Dylan?
Well, don't forget that Greenwood Law Bill of Rights, and that's first and foremost, I will not represent myself in a court of law. Second, I will not do law enforcement's job for them. 3, I will not make statements when stopped by law enforcement. 4, I will not consent to searches when stopped by law enforcement. And 5, I will not be my own star witness for the prosecution. It's not a crime to know and assert those rights. WTOB listeners, stay safe out there. This is For the Record with Greenwood Law, signing off.